Hello and welcome to Podcast Bites by India Law LLP. I'm Ashish Shukla and today we'll be shedding light on the intricacies of the procedure of obtaining societal membership in a city like Mumbai. Owning property in Mumbai is the ultimate dream, but that dream often comes wrapped in complex web of legalities. Most buyers assume that if they have a registered sale deed in their hand, they are automatically part of building's cooperative housing society. But what if your property is a basement or parking space? In a significant judgment delivered on February 2nd, 2026, the Bombay High Court addressed a fundamental question. Does owning a secondary space through a registered deed entitle you to a seat at the society table? The answer provided by the Honorable Court in the case of Amanul Ekramul Ansari versus the state of Maharashtra is a wake-up call for property buyers. Let's look at the facts. Back in 2019, the petitioner Amanul Ansari purchased a basement and a parking area via a registered deed. In August 2020, he applied for society's membership. And when the society didn't respond within the legal time frame, Ansari invoked Section 22 Clause 2 of the Maharashtra's Cooperative Societies Act, claiming what we call a deemed membership. Initially, it worked. The appellate authority ruled in his favor in 2021, but the society fought back at the revisional level, arguing that a basement and a parking area simply do not meet the legal definition of a flat. Ansari took the matter to the Honorable High Court, arguing that the authorities shouldn't act like a mini trial court to judge his title. If the society stayed silent, he should be in. Here is where the Honorable High Court set the record straight. The court held that the right to membership isn't born from a cleverly worded contract or mere physical possession. Instead, the membership is strictly conditioned upon owning a flat as recognized by the sanctioned building plans. The petitioner relied heavily on the deeming provision, the idea that silence equals consent. However, the court ruled that this only works if you are statutory eligible. If your unit doesn't legally qualify as a flat, no amount of silence from a society can magically transform you into a member. The most technical yet decisive part of the judgment centered on the floor space index, what we call is the FSI. The court looked at the architect's certificate and noticed something critical. The basement and the parking spaces were situated outside the FSI used for the building's construction. In urban planning, FSI reflects what is sanctioned for actual habitation or commercial use. Units outside this are typically common areas or appurtenant facilities. Unless a basement is shown in the sanctioned layout as a self-contained independent unit, it cannot be treated as a flat for membership purposes. The High Court dismissed the petition, reinforcing a strict rule. Sanctioned urban planning takes priority over private contracts. A deed cannot transform a common area into a separate unit for claiming membership. So before you buy, always verify, is the unit part of the sanctioned FSI? Does it meet the definition of flat under Section 154B of the Maharashtra Cooperative Housing Society Act? Because in Mumbai real estate, the flat truth is all that matters. Thank you for listening to the Podcast Bites by India Law LLP. I'm Ashish Shukla, and I'll see you in the next episode where we continue exploring key legal developments shaping India's regulatory and constitutional landscape. Until then, thank you for tuning in.